SJC-13711, Commonwealth versus Erik A. Ferrara.
Okay.
Good morning, Your Honors. May it please the Court, Adela Aprodu for Mr. Ferrara. I will just very briefly address the Gordado issue. I think it has been addressed quite a bit in the last few months. So I think a new trial is appropriate here because the only exception that the court made to the Gordado as of right now would be the Bookman case. And in Bookman, the difference was that there was direct evidence in the testimony of the officer that the two co-defendants were unlicensed. Not only was there no such testimony here, but there was absolutely no evidence here that the defendant could not possess the firearm or did not have any license. So for that reason, I do believe that in this case, a new trial is appropriate. Unless the court has any other questions about Gordado, I would like to move on to the motion to suppress. Thank you. I think the first issue to address is the Commonwealth's contention that the issue was not preserved, that the inventory search issue was not preserved. And I do want to point the court to the record appendix. It's number 18, and that's the motion to suppress that was filed by trial counsel, specifically paragraphs 2 and 3. Both of them talk specifically about the backpack at issue here, and paragraph 3, in fact, talks about the fact that the backpack search was not a valid search incident to arrest or inventory search. And I do submit that based on that, there is sufficient evidence here that the issue was preserved for appeal today. And so again, if there's no questions about the preservation issue.
Can you just give me that paragraph number again,
I
please?
apologize. Number 2 and number 3,
Okay.
I believe it's the record appendix, page 18, it's 18 on the bottom right.
You also dropped your voice a little, at least I couldn't hear. What do those paragraphs say?
So the first one says the police did not have probable cause to seize or search the backpack at the time that they did so. That's number 2. And number 3 states the search of the backpack was not a valid search incident to arrest or inventory search, and then it cites to 2 cases, one dealing with an inventory search, Ortiz, and one dealing specifically with, I believe, with the search incident to arrest, which was Rose. Mm-hmm. So I do believe that that issue was preserved for the purposes of appeal today. And so again, I just want to make sure there's no questions about that. So moving on to the inventory search itself. I think when we look at inventory search, there's always have to have one thing in the back of our minds, and that is the fact that an inventory search is not an investigative search. And then we can move on to doing the analysis. And I think that the case of Commonwealth v. Silva talked about and split the inventory search issue into 2 prongs, so to speak. And Silva says, impoundment of a car and an inventory search of a car are not synonymous, and a constitutional analysis is not unilateral. This issue was also expanded upon in Niccolo. And in that case, the court said, the lawfulness of the inventory search subsequent to impoundment implicates distinct standards from those governing the lawful impoundment of the vehicle. So if I were to do like an analogy here, I would say it's kind of like an exit order and a pat frisk. Even though they're kind of together, they do have different standards that we apply when we analyze them. And so the first issue when looking at a motion to the impoundment is the constitutionality of the decision to impound the vehicle itself. And for the purposes of this oral argument, I did go into my brief in great detail about why I believe that was unconstitutional, but I don't necessarily want to focus on that unless the court has specific questions about that issue. I think the strongest issue for Mr. Ferrara goes to the second prong. And to put it simply is, once you lawfully decide, assuming it's lawful, you decide to impound the car, what do you do with the property that's in the car? And I think that that's what the issue comes up here.
I thought the argument was the police were required to, or should be required to, suggest an alternative or ask about alternatives, correct?
Correct, but it's a little bit different. So when you impound the car, my position is that if there's a third party and that third party is licensed and can take possession,
Right,
they
but-
can do
okay,
that.
So here we have two people, both don't have licenses. The turning point in this case, as I see it, is whether the police had to say, do you have someone? Or if the defendant had said, I have someone, and neither of those things happened, correct?
I think it's a little bit different than that, respectfully. I think that's as to the vehicle itself. So as to what happens to the moped, the officer testified that he was not told by the defendant that he wants somebody else to take possession of it, and that's uncontested. So the issue as to whether or not the vehicle should have been taken possession by someone else, I don't think is necessarily an issue because the defendant didn't request that. And that requires a request. Whether if you want a third party to take the car or the moped here, you need to request that. But it's a different standard. When you look at, once you decide, I have to impound the car, what do you do with the property? At that point, I believe that the case law mandates a mandatory or an affirmative duty from the police to ask the defendant and the passenger, do you have personal belongings? What do you want to do with them? With the caveat that there's no reason to believe there's contraband and there's no reason to believe that there's any public danger by what's in the items. And I think the case that talks about that is too key.
I'm confused, because if you satisfy the first prong that they need to take the property away, they need to take the moped away, then you're inventorying to make sure that the police don't, run off with things or lose things, right?
Yes, and that's exactly what Niccolo talks about. And they talk about the fact that if you don't have to keep the property in the vehicle when you impound it and you let the other party take possession of it, there's no reason for you to be worried about the issues that that impoundment actually presents. And so that's what I'm saying here, that the issue is in Niccolo, the appeals court interpreted the Abdallah case, which Abdallah just involved an inventory search pursuant to an arrest in a hotel room, so not necessarily a car. But in the footnote in Niccolo, I think the court very clearly says that Abdallah instructs that after the initial determination, so the first prong of the test is made, the defendant should be asked his preference as to the disposition of his property. Again, the defendant should be asked his preference as to the disposition of the property, not the car, not the moped, but the property in that car or moped.
Abdallah was a search of a hotel room or something, right?
Correct.
And this is a backpack in the hotel room.
Correct.
Right.
But
Okay, so you're extrapolating Abdallah to the inventory situation.
The appeals court did that in Niccolo, in the footnote.
Different court, so.
Correct,
Right.
but the appeals.
So let me ask you, so here, if you say, and we have to drill down, but if the police hypothetically had the ability to inventory and possess this moped because of the threat of theft, you're suggesting that they can't find out what else is inside the compartments of the vehicle that are unlocked?
Correct, because.
Even if a policy says you can look at the compartments unlocked to see if there's a diamond ring in there, or, all those hypotheticals that never exist. We always find guns and drugs, but.
So the caveat is that before they can impound a car, they have to make a decision, what are you gonna do with the property? So what are you gonna do with this backpack before you impound the car? You've already decided you're gonna impound
But
it.
isn't that all governed by the policy?
I don't believe so. I believe that that's governed by Niccolo, which is the latest case in the string of it, which says that the defendant should be given an opportunity to take his property. And in fact,
Excuse me, is Niccolo the case where the grandmother is already taking some of the property and the police just didn't give the grandmother all the stuff because they wanted to look at one of the things? And this is a little different because when you have the moped with the backpack under the seat, the police can't even see that there's a backpack initially, correct?
correct, they have to lift up the seat, and you are correct as to what the Niccolo case is. But Niccolo basically talked about the fact that when there's an available third party, the grandmother, and there are belongings in the vehicle that's about to be impounded, the defendant should be given the opportunity to give those belongings to the third party before they impound the car.
But they, if you think about, I think your case would be stronger if the backpack was in a basket that was visible to the officers. Like, they didn't even know they had to start searching, in some sense, the moped, did they not, before they even discovered the backpack, correct?
Correct, but I think that, again, the wording, and it is in a footnote, as I said, but the wording talks about the fact that the defendant should be given the opportunity to take the property away. And so my position would be that the police should have asked the defendant, I'm sorry, the driver who was being arrested and defendant who was free to go, do you have belongings in this car? Yes, what is it? The backpack. They take the backpack, and again, there's nothing here to suggest that there was any issue about contraband or any issue about a weapon or safety, and let him take it
Well,
and
didn't
be
the
on his
officer
way.
actually testify that he immediately felt that there was something heavy inside the backpack that felt like a gun?
I think he said it was something heavy. I'm not sure that he said it was a gun, because I think he had to open it up to actually see that it was a weapon. So I don't think that there was sufficient testimony there about there actually being some sort of issue about the contraband.
You would
or-
be in a stronger position if the decision was made to impound and the defendant said, I'd like to get my belongings before you take my moped away.
Certainly, it would have strengthened the position, but I believe that he would still, again, based on the fact that it creates, in my view, it creates, the case of Niccolo creates an affirmative duty on the police to ask. And it's very different than the issue. The issue with the moped itself or with the vehicle itself, there's case law that says the police is not supposed to babysit or stay with that car until somebody, a third party, becomes available. But it's not the same with the personal property. And we have to keep in mind that this is an individual, my client, who had no warrants, who was not a part of this situation, who was free to go at that point. So there's no reason why he shouldn't be able to be asked to take your property and go. I think the issue here is that it was a moped and it's smaller, but if you imagine a
Was
car.
the driver free to go?
No, the driver was under arrest because he had a
Or
warrant.
how is the officer to know that the backpack did not belong to the driver without your client saying, hey, that's mine?
Well, I think that that's what the affirmative duty that's what the affirmative duty I'm talking about creates, a requirement from the police to ask, sir, you're free to go. Do you have any belongings you want to take before you leave?
You're asking us to add to our jurisprudence, correct?
Yes, to extend Niccolo.
And Abdullah,
And
as you
Abdullah.
see it, to this situation.
Correct, and I think the rationale for that is very simple. If a defendant who's under arrest and who's going to be taken into custody is given the opportunity to have somebody else, a third party, the grandmother or the passenger, take his belongings from the car, why shouldn't a passenger who's committed no offense, who has no warrant, and who's free to go, why should they not be given the same opportunity to take their belongings before any type of an inventory search? And again, I want to highlight the fact that they're inventory searches, so it's not an investigatory search. You can't just go and search to see, did these people commit any other crimes or anything like that, unless you have a reason. You have to have some justification to open that backpack once you determine that it doesn't belong to somebody and it's going to be taken as part of the impoundment.
So this would be a precondition, in your view, before compliance with whatever the local inventory policy is?
Correct. It would be that, and I think the case law creates that duty, creates that actual police officers telling them you have to take it. And I think the Commonwealth, at some point in their brief, conceded one of the other points, which related to the car. They say in their brief, if Mr. Pena, the driver, asked the police to give the moped to a third party, the police should have listened to that and should have done that. It's the same concept here. The only difference is that here it's an affirmative duty of the police to ask rather than the defendant to ask. I think that the defendant, in the context of the Commonwealth's concession, the defendant, and I think it's very clear from all the cases that are cited to, it's the defendant that has to say, I want the third party to take the car. And it's equally clear, based on Abdullah and Niccolo, that when you're talking about the property in the car, the police have to ask and give an opportunity to the
What
people to
if
take.
when the officer lifted the seat up, the firearm was just there and there was no backpack hiding it? Would he have to ask the passenger, hey, is that your firearm? You want to take it with you?
No, Your Honor, and there's actual case law that talks about the fact that when you do an inventory search, the exception doesn't apply. This affirmative duty doesn't apply when there's contraband or when there's a reason to believe that officer or the public safety is involved, which is not present here at all. The defendant was by all means cooperative. He gave his license. They ran his name. They ran everything.
So your client's better off because the backpack concealed the firearm?
Well, I mean, I think, yes, I think to some extent, yes, I think that.
I'm just reading from the Commonwealth's brief, and you correct me if it's wrong. On page 8, he picked up the backpack and felt something hard inside of it. Based on his training and experience, he believed the object was a firearm. He opened the backpack and found a Sig Sauer P320. So if that's, unless he's mischaracterizing the facts, they knew there was a problem with contraband right when they touched the backpack.
I think that's the issue, that if that is in fact, and I'm trying to pull it up, but if that is in fact accurate, I think it would be an issue of whether or not that is, there was sufficient evidence of that brought to at trial in terms of the actual testimony that was presented in regards to what he actually felt. Because if he just felt that the bag was heavier than normal, then I think it would be a very different issue.
Well, that's why I asked you about whether if he just saw the firearm, he'd have to ask your client if it was his and then allow him to take it, because I read the testimony the same as Justice Kafker did, which was he felt the backpack and based on his training and experience understood that there was a firearm inside it.
I still also have this issue with this, that you're drawing this and putting this in the same world as Nicola. There was a factual finding, was there not, in Nicola by the trial judge, that this was not an inventory search. It was a search for evidence. And that was the turning point because of the arbitrariness of you give some to the grandmother, but you didn't give the backpack. And so there was a finding that this wasn't an inventory search. There's no suggestion here that this was a search for evidence. This was towing it. I've got to look to make sure that I'm protected as the police officer, that no one's going to accuse me. No one's saying this is your client's backpack. So where is there any suggestion that this was anything other than an inventory search in incident to the decision to impound?
Well, I think the difficulty lies in the fact that it lies in the fact that here, I think it was right at the beginning of the search that this happened. It was the first thing that he touched. So we're not sure. I think in Niccolo, it took a little bit of time before they got to the backpack. And then the issue was that and the same issue was present in Abdallah in terms of some items were given to the third party and some items were not. Right. I think here, we can't know that didn't happen here.
Okay, but the facts are what they are. I mean,
Correct.
If there were different facts, it'd be a different case. But the facts of this case are that this is what happened. So again, I'm saying, where is the suggestion that somehow this was not a proper inventory search? And that's what I just would like to get to.
Well, I think that it comes from the fact that, again, my position is that there's an affirmative duty to ask if there's property, and that's where it comes from. So if the second prong is not met, then it makes the search unconstitutional pursuant to the inventory search exception.
Okay, thank you.
Thank you, Your Honors. Thank you.
Attorney Hanson.
Thank you, Your Honor. Good morning. If it pleases the court, Arne Hanson of the Commonwealth of Massachusetts. With respect to the Guardado issue, I'd like to address this first. Guardado created a new prospective rule that said we had to now prove licensure moving forward with all the gun cases. There was a loophole created by that decision, though. Any case that wasn't final or still pending appeal, those convictions are essentially vacated if the defendant chooses to file an appeal and challenge those convictions. The defendant in this case falls within that gray area, where during the pendency of the defendant's case, the Commonwealth was not required to prove that the defendant didn't have a license. It was still an affirmative defense. So there was no reason to gather that evidence or present it to the court. What we have here is a subset of defendants that are convicted felons and therefore prohibited by statute from possessing a license, who were tried under the old rule, who can now challenge their convictions and have their convictions vacated as a result of the Guardado decision. So what the Commonwealth is asking succinctly, because my brief didn't go to this court, it went to the appeals court, is to get rid of that exception and clarify that if you are a convicted felon,
So you want us to adjudicate, the court to adjudicate, and say as a matter of law, the defendant doesn't get a new trial because the defendant was under 21 or had a felony?
Correct. And it's harmless beyond a reasonable doubt because, as a matter of law, we know that they're a prohibited person.
How
Well,
much?
but none of that evidence is in at the trial because understandably, the Commonwealth didn't put it in because it didn't understand that it had that burden under the Second Amendment.
Correct.
Right, so but that makes it very different than the Netter case, where there was evidence of, I think, an underreporting of $5 million in income, and then it was harmless beyond a reasonable doubt as to whether that was material misreporting. Here, there's no evidence in the trial as to the prior felony conviction, so it's a little different.
Yes, and that's fair. And I think there's
So
going to...
let's move on to the motion to suppress. That's what we're here for.
Okay. With respect to the motion to suppress, it's clear that the officers followed the inventory policy. The purpose of these types of motions and the inventory policies are to safeguard the belongings in the car, to safeguard the police from accusations of stealing or losing belongings, as well as to protect the public from items that might be found in the car that are dangerous, such as weapons or illicit substances. The inventory policy from the Eastwater, Bridgewater Police Department follows that to the T. It says this is the purpose. It follows the case law Commonwealth v. Leck. If the police choose to initiate a traffic stop, they're responsible for the location of the stop, and they're also responsible for the vehicle. Here, the vehicle was stopped at a cul-de-sac. So it wasn't illegally parked, but it was on the street.
Can't you just keep a moped in a cul-de-sac? Would be like offensive to the HOA? Like, why can't we just keep a moped on the sidewalk?
Because of these specific instances here, so you can protect the car, or the moped in this case, from vandalism or theft. There was specific evidence in this case that this moped could be started without a key. And there was also evidence that the compartment inside this moped couldn't be locked. So if you leave the moped there, somebody could start it and drive off with it, or somebody could ransack it, go through it, and there would be nothing that anyone could do with it because there's no locks on this vehicle. And that's why the officer made the right choice to do the inventory of this vehicle. Now, if you look at Crowley v. Chester, it states that the test here is not whether this is a high crime area, it's whether the likelihood of a theft or vandalism is high given the circumstances. Again, where this car or this vehicle could be driven off by anyone, that is very likely to happen, or at least in theory.
So I guess that, not to fast forward too much, but so let's just say the moped, and now anybody could take it for a joyride or ransack it, and so it has to be impounded. The next question, I think, that opposing counsel is really arguing is that at that point, the officer needed to ask, do you have property here, dear defendant, passenger, because you're not under arrest. Do you want to just grab it and go?
Yes, and I think the case law here is very well established with regards to the actual vehicle. So if there's another person on, and I'm getting there, but there's another person on scene that could take control of the vehicle, that person should be permitted to do so, and the officer has an obligation to let that person take the
Right, but
car.
here we have two unlicensed drivers, so nobody can take the moped.
Right, so my analogy is the same for materials that might be found inside the vehicle. So if you look at Oliveira as well as Ellerby, they hold that where neither the driver or the passengers ask the officer for a third party to take control of the car that's not on scene, the officer has no affirmative duty to let that person, to then ask that person, hey, do you want someone else to take the car? If one of those individuals, either the driver or the passenger, asks, hey, in Oliveira, it's a very good example. It was Oliveira's girlfriend's car. He parked it in a parking lot in a shopping center. He asked, hey, can my girlfriend come take this car? She's the rightful owner. She can get here in X amount of time, and can she take the car? And the court ruled that he should have been given that opportunity because he asked for it. But conversely, the officer does not have an obligation to ask the occupants of the car to then get some third party from who knows where to come take the vehicle. It's only when those individuals ask. That's with regards to possession of the car. My argument is it should be analogous with materials contained inside the car. In this case here, nobody asked, can I grab my belongings out of the
Why
bag?
should it be the same?
Because it's property. Car is property, the items inside are property, they all belong to someone.
If,
Imagine it was the person in the backseat of a car.
I'm sorry?
Imagine it was, there's two people, one person's getting taken away, car's gonna be impounded. There's a purse in the backseat of the car. What happens in that case?
The purse would be inventoried?
So you're saying nobody would say, hey, do you wanna grab that purse before we take this car away? Nobody's gonna, I mean, isn't that just,
I'm saying that the officer doesn't have a duty to go through every single item in the car and say, do you want this, do you want that, do you want that? I think the law is very clear with regards to the car itself.
no,
that-
I understand, we're talking about the property in the car. So if there's something in there that appears to be a personal item, right? I'm just asking, just in real life, are you saying that, nobody says anything, whatever the person to whom the personal property belongs is kind of, surprised by this whole thing and isn't thinking straight? The police officer is just going to take everything, not going to, I mean, is that just how they do it?
I think that would be a fair way to do it, and I think that's the way that it's been happening and has always
Is that
happened.
how it happens? They don't say, do you want your bag before we take off with this car?
I think that's just the way that it happens. Where nobody says, hey, my bag is here, can I grab it before we go? I think it would be unfair to put the duty on the officer to then go through every single belonging
Yeah, no, I
in the
understand.
car
I
and say, do you
understand your
want this, do
point.
you
I'm
want
just trying to
that?
get where the line is,
Right.
right? So if you see,
I think it's a very delineated line. I think if the individual asks, then it's very clear the officer has to respect that. But the officer doesn't have a duty to then ask the individual, what do you want out of this car?
if there were a licensed operator, not the operator, but the passenger in this case had had the ability to operate the moped lawfully, can you run out for me what the rule is in your view with respect to the property in the moped?
If there's, I think the law is very clear. If there is somebody that is on scene that isn't intoxicated and has duly licensed
Yeah.
to take the vehicle, they can take the vehicle and it shouldn't be inventoried. I think the
Okay.
law is very clear
So
on
the
that.
question is, what's the principled line to distinguish that passenger's relationship with the property in the vehicle? Just based on the fact that he has a license gives him a different expectation of privacy with respect to his own property in the vehicle?
I'm not sure I understand the court's question.
Okay, so I think what you just said is that if he had had a license and could drive away the moped, the officer couldn't have searched the moped.
Correct.
Okay, so that person, just because he does, the passenger, who wasn't doing anything unlawful because he was a passenger, just because he doesn't have a license, the Commonwealth's position is his entitlement to prevent a search of his own possessions in the moped changes, just because he's not licensed.
I understand what you're saying. I don't think there's a direct line. I think the line that I'm drawing is, and I think the crux of the issue is whether or not the individual asks to remove their belongings should be treated the same as whether or not an individual asks for a third party to pick up the car. So I'm saying that the onus is on the individual who presumably owns the possessions inside the vehicle to ask the officer, can I grab this?
How does that square with the purposes of the inventory search?
The inventory search just needs to make sure whatever's left in the car is tracked so that the officers can maintain that without it getting lost, but also prevents dangerous items from being left in the car.
Right, so if they're not going to be left in the car, then the purpose is, In other words, they're not going to end up in the custody of the police, then those purposes aren't really furthered, are they?
Right. But again, here we have a case where the officer is going to take possession of the moped. Nobody has said, my stuff is in the moped. He doesn't know what's in the moped because it's in a compartment under the seat. He only discovers the firearm after he's initiated his search. And there was nothing before him to suggest that he should not have searched the vehicle because, again,
What if the backpack was in a basket? And so the officer knew there's a backpack here. Would that make a difference in terms of whether he had an affirmative obligation to ask the passenger, hey, do you want to take that? Is that yours?
I think from a legal perspective, no. Because
Okay, so
again,
it doesn't
it's
matter that it was not visible to the officer and it was under the seat from your perspective?
not with respect to who has the duty to request what happens with the items.
And what if the backpack had been on the passenger's back?
But yeah, then you can't search it without probable cause. I think that's a completely different argument. He's not investigating a crime here. He's effectuating a motor vehicle stop because of a civil infraction, and then as a result of that discovers that one of the operator has a warrant, so then he's dealing with that. And because the defendant didn't have a license, he had to deal with the moped before he could effectuate the arrest on the warrant.
The fact question that I asked earlier from your brief, I can't find the transcript, at least right now. Is it clear that he identified the possibility of a gun by touching as opposed to opening the bag?
That is my recollection of how it happened.
Which is? What's your recollection?
That he picked up the back, he opened the seat, he picked up the backpack, felt that there was a gun in there, based on his training and experience, opened the backpack, lo and behold, there's a gun in there.
And do we have that transcript? It's so, I see there's a motion, page 15. Do we have that in our record?
It's the defendant's appeal, so I don't know what was sent, but I certainly had copies of the
Okay, so
transcription
it's-
preparing for this.
But you think it's in our record? I just
I
couldn't
would
dig it
assume
up.
so.
Well, that's good.
Again, it would be part of the trial file, but
Yeah, but we don't have the whole, we don't always have the whole trial file.
right. I don't know if it would be part of your record as well, but there's photographs of the backpack in question. It's not a large backpack.
Not going to help
Yeah.
us any, because it's the feel issue.
Right.
You draw a distinction saying that when he picked it up on page 8 of your brief, he could tell it was a firearm.
Right. So if that's, I'm not, during the facts, the way that I write my facts is very straightforward. If that's what he said, that's what I put in.
Why don't you give us the transcript?
Yeah.
Yeah, I can certainly email it to you.
Okay, great, thank you.
Okay. All right.
May I ask a question? On the sufficiency of the evidence and the defaced firearm,
Yes.
can you address where the charge was, where the jury were instructed in one way, how the evidence was sufficient with respect to how the crime was instructed?
So with respect to the Commonwealth theory of the case, it was always that the defendant was in possession of a firearm with a defaced serial number. Certainly there wasn't any evidence that he defaced it on the side of the road while he was riding the moped. So if you look at the transcripts, and I cite it in my brief, I think it's page 112. ADA Gans has a conversation with Judge Dilarati about the jury instructions, and the primary jury instruction focuses on the actual act of defacing. So that was going to be given. There is a supplemental jury instruction, which ADA Gans has a conversation with Judge Dilarati about, which discusses mere possession of a firearm with a defaced serial number. That's another way that the Commonwealth can prove guilt beyond a reasonable doubt in these types of charges. And they go through that, and both of them agree that that's an instruction that's going to be given. That instruction is then given on page 143 of the transcript, which is the jury instructions.
I didn't see that there. I only see an instruction that that the defendant was to remove, deface, alter, obliterate, or mutilate the serial number.
So referring to page 143, I don't know if Your Honor has that in
I
front of
have
you.
it right in front of me.
It's the first full paragraph or the second paragraph in there. It starts with, "You heard some evidence in this case suggesting the defendant possessed a firearm with a defaced serial number. If you find that fact to be proven, you are permitted to accept it. Also as proof, the defendant was a person who removed, defaced, altered, obliterated, or mutilated the serial, or the aerial, the serial, or identification number on that firearm."
Okay, so
that's the
you're
instruction.
You're reading the first sentence as being an alternate path. The jury would have understood that the first sentence was an alternate path to the second sentence.
Correct.
Chief, could I clarify one thing? Counsel, so I think this is really important for us. We have the sergeant's testimony at trial.
Right.
That's what's in here. I don't know that we have the testimony at the motion to suppress. And I think, don't we need that?
I certainly agree, obviously, to evaluate what was presented before the court. I can send a copy of that transcript to the court.
Justice Dewar may have.
I think it's available in the clerk's office, and it was not on our iPads. I apologize
Oh,
for
is
not
that, okay.
highlighting that, but we do have, the court has it. It just didn't make it electronically into all locations.
Thank you. I appreciate that. Thank you.
Can I ask a follow-up question on this defacement issue? So I read the statute as creating two crimes, 11C. Number one is receiving a defaced firearm, and number two is defacing a firearm. And then there's a further provision in 11C that says it shall be prima facie evidence that a defendant committed a violation of 11C if a defendant is in possession of a defaced firearm. Do you understand the statute the same way?
Yes.
So the complaint here clearly charges only defacement of a firearm. It does not charge receiving a defaced firearm. Do you agree with that?
Yes.
And then at the charge conference, the ADA specifically said she did not want a receiving jury instruction. She only wanted the defacing instruction, correct?
Yes.
And so what's your best case that it can be proof beyond a reasonable doubt that a defendant himself defaced a firearm, that he is in possession of a firearm that is defaced?
So the Ferrara case, which I cite in my brief,
That was a receiving case, was it not?
my understanding of the statute is that if you are in possession of the gun with a defaced serial number, that is prima facie evidence that you defaced the gun.
By receipt.
Right.